Hello, this is Attorney Brian Pendergraft with the Pendergraft firm, and the topic for today's video is what if an occupant has a fake lease in Maryland and strategies for dealing with fake tenants. And again, my name is Brian Pendergraft, and I'm a real estate and landlord-tenant attorney, and I'm licensed to practice law in both Maryland and the District of Columbia. That said, I have to give a quick disclaimer. This is legal information. This is not legal advice. For legal advice, you can contact an attorney that is licensed to practice law in your jurisdiction. I'm assuming, I guess you're watching this if you're a Maryland property owner. So, yeah, you may want to consider contacting me or someone else. You don't have to contact me. So, let's get into the order of the presentation. So I have 14 points here. So what is the most common situation that I see? In fact, let me back up really quickly. So I'll go through these 14 points. So the first point is what's the most common situation that I see? That is a bank-owned properties. That is when someone purchased a real estate-owned or called a REO property, or it really means a bank-owned property after the bank has foreclosed on someone. A lot of times there will be someone who is a fake occupant on the a real occupant on the property, but they will have a fake lease agreement, or they will be a fake tenant. They will have a fake tenant they'll have a fake lease with the former owner. So that's the most common situation that I see. But there's also other situations, and I'll discuss those too in my in the first point. Second point is posting a notice to the premises, asking them to contact you. So I discussed that. Third point, I discussed demanding a copy of the lease agreement. Fourth point, I discussed how to figure out if a lease is fake. Fifth point, why consider offering a cash for keys agreement. So a cash for keys agreement is when you pay someone to leave. I know you're thinking like, why would I just, pay people to leave? They're harming me. If anything, they owe me money. Yes, they do. But it may be more beneficial for you to pay them to leave if in fact they're going to leave and you're not going to just have a property that's just not making any money. Point number 6 is never give cash before receiving the keys. So that's because of point number 6, because I've had situations where people have given the cash and then the tenants have not left. So you don't want to do that. Part number 7, I discuss escrow agreements. Part 8, I discuss contacting the authorities. So a lot of times you contact the police, they will not, they won't carry out an eviction, but they will tell you who sometimes they'll visit the property and they will be able to gather information. So they may be able to get a copy of the lease agreement, or they may be able to get a copy of their licenses, things of that nature, so they can see who these people really are. Point number 9, I discuss contacting the former owner, because a lot of times you can contact the former owner and they'll confirm or deny whether or not they've actually leased the property to the occupants. Part number 10, starting at part number 10, we start getting into legal action or legal stuff that you can do. And then we kind of escalate from there. So we start with legal demand letters, because a lot of times they may leave after receiving a demand letter from an attorney, but that doesn't work. Of course, we have to escalate things even further, which brings us to point number 11, actions for possession. And then point number 12, actions for monetary damages. So possession, what do I mean by actions for possession? That means actions for, because possession is a legal term. What I mean is actions to evict people. That's what it's called in point number 11. Point number 12, actions for monetary damages, aka money. So like trying to get back the fair market value of what you have of the person occupying the property for X amount of months without you being able to get paid. Point number 13 is, what if they really are a good faith tenant? What happens then? So I kind of discussed the protection of homeowners and protection of tenants in Foreclosure Act. And I kind of give a brief discussion of that. And for point number 14, I discussed what if they were scammed? So a lot of times people will end up getting scammed and onto a property. So that is it. That is points 1 through 14. So if you are watching this on YouTube, go ahead and like and subscribe, because that will help. That will help me out. That'll help me out. And I also have an article version of this presentation as well. So you can go, so you don't have to sit through hearing me babble. I think the article is a lot faster actually if you just go read the article. But who knows? I may you may like listening to me. You may like hearing me riff and my cool voice and whatnot. All right. So moving on to the point number 1, most common situation, bank-owned properties. So The most common situation where this occurs is when an investor purchases a bank-owned property, also called a real estate-owned or REO property. There will often be a squatter inside that claim to have a lease with the former owner. As far as we don't know who these people are. They could be using fake names. They could also be, they could very well be lying, or sometimes they could even be telling the truth. They very well had a lease with the former owner. Other situations where this may occur is a stranger may just move into one of your properties out of nowhere. So it may not have been a bank. It may have just been a property that you had just sitting aside somewhere, or maybe someone just decided, hey, I'm just going to move into your property because they one of your properties. Another situation is that you may move in a family member or a friend. You may allow them to stay at the place, and they may just create they may just create a fake lease agreement and claim to have a lease agreement that is from the owners. So those are other situations that I can think of. Is there anything else I can think of? That's all I can think of for now. But if I think of any more, I'll definitely come back to that. So point number 2, that is post a notice to premises asking them to contact you. This is, of course, assuming that you don't know who they already are. So one of the first orders of business is to attempt to get the occupants, or is attempt to get into contact with the occupants. And one of the best ways to do that is to post a notice to the premises asking them to contact you. You can also ask them for a copy of the lease agreement, and you can incentivize them to contacting you by offering a cash for keys agreement, or you could also warn them of legal action if they do not contact you within X number of days. At least in my experience, a lot of times once people are threatened with legal action, they would much rather they will at least try to put in a phone call to stop the bullet headed their way. All right, point number 3, demanding a copy of the lease. So you'll need a copy of the lease agreement. After all, these people are claiming that they are tenants. So in many cases, you won't even have to ask for the lease agreement because particularly if the occupant is a professional fake tenant scammer, they will give you a copy of the lease. They'll proudly give you a copy of the fake lease, saying that, hey, I'm a real tenant. Check out this lease agreement that where I pay $200 a month to live in this mansion. So that tends to happen a lot. But that said, you need to ask a copy of the lease agreement so you can try to investigate it and determine if it's real or not. Which brings me to point number 4, how to figure out if a lease is fake. So there's a number of red flags that I look for when I attempt to spot if a lease agreement is fake. So for one, lease looks unprofessional. Another red flag is that by lease looks unprofessional, I mean, let me elaborate that a bit more. So it looks like something that they just kind of typed up themselves without, copy and pasting from perhaps various leases that they found online, or maybe they even just written it up themselves, but it doesn't look professional. It's not like let's say a realtor contract, or it doesn't look like an attorney drafted contract. It looks like something that they came up with themselves. So that is one of the red flags. Another red flag is a ridiculously low amount of rent due, or maybe even no rent due at all. So that is another huge red flag. Red flag number 3. The signature on the lease agreement does not match the signature on publicly available documents. So that's something else that I look for. So I try to find publicly available documents maybe like a mortgage note, or maybe a prior deed, or something that was I think mortgage note is probably the best example, but you can find publicly available documents with the former owner's signature on it, and you can compare that with the lease agreement signatures. And if they don't match, then chances are it was probably fake. So another red flag I look for is the date of the lease is after the foreclosure occurred. That tends to happen. A lot of times the professional tenants will they will just put in the fake date that was after when the foreclosure occurred, when the former owner didn't even own the property at that time. All right, next red flag. So former owner was dead at the time of execution. So yes, this actually happened in one of my cases before, where they claimed to have a lease with the former owner, and the date was actually after the owner passed away. Now you can find out if someone has passed away or not by checking what's called maybe online obituaries or a what's I'm looking for, the an estate search. That's it, or by doing an estate search, so you can see if the former owner is alive or not. And the last point is that I can just kind of feel it when I look at a lease agreement. Like I've seen so many. So this might just apply to me, and perhaps not to you, or who knows, maybe it would. You know what I mean? You may just have those same sort of spider senses where you can look at a lease agreement, you can just be like, man, this is fake as hell. But that kind of, again, it may just be so blatantly obvious, or it just may be something that something that I can tell just from my years of experience. So. I mean, to that point, you know what I mean? It's not so much that I'm an attorney that makes me a professional at spotting like these fake lease agreements, right? These red flags are what I've learned. I actually learned a lot of this from real estate investors that have been dealing with fake tenants for years, right? So I actually learned the game from real estate investors, so that had to deal with this. All righty. Point number 5, the case for cash for keys agreement. So, I consider cash for keys agreements. So, in a perfect world, fake tenants will be evicted in 2 or 3 weeks after taking legal action against them. Unfortunately, we do not live in a perfect world, and it can often take months in order to get the property back. And due to the pandemic currently going on right now, court wait times have doubled or tripled, depending on the jurisdiction that you're in. May even be longer than that. And each month that goes by represents cash that you could have been paid. And for that reason, it may be more cost effective to offer a cash for keys agreement to the occupants. So that's why I don't even think I said what is a cash for keys agreement. So a cash for keys agreement is an agreement where you pay someone to leave, hence cash for keys. All righty, point number 6. Never give cash before receiving the keys. So why? Why would you not give cash before receiving the keys? Because they'll take the money and not leave. So maybe I've seen too much in my lifetime, but I've had a case where a tenant refused to vacate, or at least I've seen a case where a tenant refused to vacate after receiving the cash. So for that reason, I recommend using agreements where the tenant does not receive the cash until after they have vacated. All right, so next point, Escrow Agreements 101. So what is an escrow agreement? So, so fake tenants, being the master scam artists that they are, will often not want to put themselves in a position where there is a possibility that they will not receive the cash after they have vacated. So in order to address that concern, I tend to use third-party escrow agreements where an attorney, such as myself, is responsible for holding and dispersing the funds after the tenant vacates. I believe that there are third-party escrow companies that will carry out this function if you do not want to use an attorney. So that's why third-party escrow agreements are a great way to go about alleviating a tenant's concerns when it comes to cash for keys agreements. Alrighty, point number 8, contacting the police or sheriff to find out who the occupants really are. So when you contact so in many situations, you won't be able to tell who the occupants really are. Perhaps they'll give you a fake name, or maybe they will even outright refuse to speak with you. So if you contact the police and tell them, or maybe the sheriffs, and tell them that you have unidentified squatters on your property, they most likely will not carry out an eviction. However, they may very well be willing to visit the property and to gather the personal information of the occupants. They may even show the sheriff copies of the lease agreement that they refuse to show you. So you can definitely get personally identifiable information by using the sheriffs if it comes to that. Point number 9, contact the former owner to see if it is a real lease. So assuming the former owner is alive, which is, again, that's something that you'll have to check as well, because like I mentioned earlier, I've had that, there was a case where they had a lease with the so-called former owner, who was actually dead at the time of the lease signing. So something that you have to keep in mind. So assuming that the owner is alive, former is alive, you can always track them down and contact them. And you can just ask them, hey, is this a real lease or not? So in order to find people, I've used social media and I've also paid people to use, and I've used lookup tools to track people down. So you can also pay a bit more to have a process server attempt to track them down. So the former owner may very well tell you that this is former, I should say lease, but the former owner may very well tell you that the lease is fake, and you can use him or her as a witness at trial if it gets to that point. You know what I mean? There's claiming to have a lease from the former owner. There's no better testimony or evidence that you could use than the former owner saying, nah, I did not have a lease agreement with them. They'll look really stupid if that were to happen. Point number 10, legal demand letters. So applying legal precedent. So often fake tenants with fake lease agreements will not listen to the current owner of the property, and a demand letter from an attorney may encourage them to leave the property. It may not, but I tend to think that it's worth a shot. So assuming that you send a letter, it doesn't work. At that point, now it's time to take legal action. And my first point on legal action is actions for possession, i.e. eviction. So you have to choose the right cause of action. In most cases, the proper cause of action is a wrongful detainer action. In fact, I would say definitely in most cases. So if it's a foreclosure purchase, it may be possible to intervene in the foreclosure case and file a motion for possession in the case. So that's so you have a district court wrongful detainer action, and again, if it's a foreclosure case, then you may very well be able to intervene in the circuit court case by filing a motion for possession in that case. Alrighty. Point number 12, actions for monetary damages. So what I mean monetary damages, that means suing people for money. So unfortunately, some judges are not willing to award monetary damages in possession actions. I think this is very common in Baltimore City and in Prince George's County in particular. But that said, it really even in those counties, it depends on the judge. I'm learning that they're kind of all over the place. I think some are more pro landlord, some are more pro tenant. So it really comes down to which judge you're in front of. But if you're in front of one of these judges that do not like to award monetary damages, then you will need to file a separate civil suit for monetary damages. And the amount of the claim can start at least with the fair market rental value of the property for the time that they stayed. And then it can go up from there for whatever other damages that you may have incurred. Maybe there was damage to the property. Maybe you had to pay the water bill that they didn't pay, or maybe you had to pay an electric bill that didn't pay. So all that stuff can be added to the civil claim. Point number, I think this is 13. What if they were scammed? So there are cases where fake tenants honestly believe they are real tenants. So So sometimes people do fall victim to scams and rent from someone they thought was the landlord. That was not. Unfortunately for them, this does not give them the right to possess the home. And you can attempt to work out an agreement with them to leave, perhaps such as a cash or keys agreement, or you can file an action for possession against them. But they do not have any special protections just because they were scammed into being onto the property. I mean, it really sucks for them, but they got to go. Point number 13. What if they really are a good faith tenant? Alrighty, so generally, let me give you a brief, what's the word I'm looking for? A brief explanation of the Protection of Tenants in Foreclosure Act, because that is what happens if someone is a good faith tenant and the property is and you foreclose on a property in particular. So in that case, you say you foreclose and a person inside the property is a good faith, aka bona fide tenant. So generally, the owners have to honor the lease agreements of the bona fide or good faith tenants. And that means you become their new landlord, meaning that they have to pay you and you have to provide them with landlord services. And let's see, next point is that leases terminable at will can be terminated with 90 days notice. So say if you foreclose on someone and they are a month-to-month tenant, Well, you foreclose an owner, there's a tenant there, and the person staying at the property is a month-to-month tenant. At that point, you can send them a 90-day notice under the Protection of Tenants and Foreclosure Act. So it's a bit longer than the standard, I guess, Maryland notice to terminate tenancy, which is 30 to 60 days, depending on where the property is located. Next point. So leases not terminable at will or annual leases can be terminated with 90 days notice if the owner intends to use the property as their primary residence. And the last point is that the eviction's cause of action change, because if you want to remove these occupants, you can't just I think I mentioned earlier, perhaps filing a wrongful detainer action or filing into the foreclosure case asking for a motion for possession in order to remove the occupants. But that is to remove squatters essentially. But because the occupants are tenants, or at least these good faith occupants, because they are tenants, the causes of action change in order to evict them. So they change. So the cause of action used to evict tenants is failure to pay, breach of lease, and tenant holding over actions. So if you need to evict them, it may be for one of those three reasons. And that is it. So that is all for this presentation. If you have any questions that you would like to be considered for the Ask Attorney P series, you can visit my website at tpf.legal/ask, and then you can ask questions there. And thanks for watching. Again, from Pendergraft with the Pendergraft firm. And I'm out. Take care.